Hello and welcome to this session on IP law and strategy for managing artificial intelligence, a European perspective. Before we begin, there are some initial housekeeping slides to attend to. The first point to note is this session is being streamed live, but the recording will be made available after the event, both through the Gowling WLG website and also the Silicon Valley Association of General Counsel all hands virtual meeting platform. For all registrants seeking California MCLE credit, please visit the linked page in the chat function, which should be there now, and complete all of the form to be filled in that will take you through to. Please do note that MCLE credit for viewing the recording will be available only if viewed through the all hands meeting CLE server, so do go through the platform rather than directly through the Gowling website if you're looking for MCLE credit. First things first, in terms of legal disclaimer, it wouldn't be a presentation from a law firm if there wasn't a legal disclaimer. Today's presentation is not intended as legal advice. It's a high-level overview and it's impossible to cover all relevant details of the subject matter. Available rights and remedies will depend on the unique facts of each situation, your applicable contract or subcontract, and the nature of your project. Of course, we'd be very happy to assist with any specific advice. Do contact your qualified legal counsel before making any decisions or taking any actions. This is of particular importance as every province and territory has its own regime. As you know, the situation is extremely fluid and is changing on a daily basis as things evolve. Your best course of action could also evolve. Please follow up-to-date and reliable sources for your information. Thank you for that. So by way of introduction, my name is Neil Hendren. I'm a partner in the UK corporate team at Gowling WLG. For those joining as part of the SVAGC All Hands virtual meeting and perhaps less familiar with Gowling, we're an international law firm. We do not have a US presence, but we work regularly with US companies and law firms in relation to international matters. We have over 1,400 legal professionals working across 19 cities from Vancouver to Beijing. Our dual centers of gravity being Canada and the UK, and both myself and Matt Hervey, who's today's presenter, are based in our UK offices in London. Having previously attended the SVAGC All Hands in person, I, and more broadly we at Gowling, are delighted to be able to participate virtually in this year's meeting. And I do hope to be able to see many of you again soon when the conference is next able to convene in person. So my role in this session is just to introduce Matt Hervey and to moderate Q&A at the end of the session. The format of the session will be for Matt to deliver his presentation for approximately the next 45 minutes or so, and we'll then have time for some Q&A through the Q&A function through the Zoom platform. So to introduce Matt properly, he is the head of our artificial intelligence team in the UK. He's also a partner in our intellectual property team. Matt is a general editor of The Law of Artificial Intelligence, which is a practitioner's handbook published in December last year by Sweeten Maxwell. The book analyzes specific legal issues inherent in AI technology, how current UK civil and criminal law applies to AI, the principles of ethical AI, emerging regulatory measures, and the use of AI in law firms and in the administration of justice. Matt co-wrote the chapter on AI and intellectual property within that book, as well as being general editor. He advises companies of all sizes on their intellectual property strategy for artificial intelligence. So without further delay, I will pass over to Matt to take us through the presentation. Thanks, Matt.
Thank you very much, Neil. That's always nice to be introduced by you. Thank you. Let me just outline the scope of the session. I'll put the agenda slide up so you can see it at the same time. So I'll make some introductory remarks about AI in Europe and the sort of range of legal issues for AI. Then I'm going to focus in on the IP rights, the classic IP rights. And you'll notice I don't count trade secrets as an IP right. That's just a categorization issue, but it seems to be popular. And how the classic ones apply to AI. And then spoiler alert, because really classical IP does not apply well to AI, I'm going to talk a bit about trade secrets and about contractual measures because they are really important from a European perspective for protecting AI. And then I'm going to talk a little bit about the unusual risk of disclosure that AI in particular presents, and really to give some guidance from, again, a European perspective on the key considerations when choosing whether to pursue a monopoly right via a patent or to rely on trade secrets. Now, normally when I talk about AI, I give an overview of a long history of AI research, and I contrast expert systems and machine learning, and I explain some of the fundamental issues with it and its potential as a tool. But I think when I'm talking to a Silicon Valley audience, that is wholly redundant. And since you leave a world in AI, I imagine you're all very familiar with the technology and its promise. So instead, I'm going to outline the importance of AI in Europe and in the UK. And many European countries have centers of excellence for AI in Europe. And it's also got a very active private sector. So the UK has the Turing Institute, a centre of excellence for AI research, which in fact combines the 5 leading universities in the UK in that field. And investment in AI in the UK has been estimated to be the 3rd highest in the world, obviously after the United States. And this infographic, which is from 2019, shows a sort of medium-term trend that AI investment in Europe has been by far the highest in the UK. Indeed, on this chart, the UK investment couldn't even be shown on the same scale as the rest of Europe. And the UK has some very high-profile AI companies which have been sold, and these include Magic Pony, which was sold to Twitter for $150 million, SwiftP sold to Microsoft for $250 million, and DeepMind sold to Google for $500 million. And AI is also a major focus of European governments. It is one of the 4 focuses of the UK's industrial strategy, and it's also aligned with the UK government's procurement. So particularly the UK National Health Service, the NHS, is very carefully devising procurement rules for AI, and that's focused through a team called NHSX. And the EU itself and many of the member states have specific AI strategies. So it's not just the UK, but also there's an overarching strategy for the EU itself. And that includes investment in AI and creating the conditions for a data-based economy generally. And that includes measures such as open data sets from government and from quasi-government, robust protection of data privacy, and data portability for consumers moving between suppliers. And as part of this, the European Union is openly keen to regulate AI. And Ursula von Leyen, the current president, actually promised to regulate AI in general, not on a sector level, but in general, in her first 100 days. And there's an open aim in the EU of achieving clear rules to attract inward investment. The idea that if you have clear written rules, then people know where they stand and they will do business in the EU. But it's also to export European values. And I think they want to build on the success of the GDPR, which was in effect exported to other countries, and to do the same to achieve ethical AI according to European values internationally. Now, those programs have been delayed by COVID, but the current timeline the EU has published is to have a legislative proposal for AI in this quarter of the year. But already lots of work has been done. They have published guidelines on ethical AI, and individual roadmaps and studies have been produced by the regulators of various sectors. And so recent examples are the aviation sector and also for the use of AI in the justice system in Europe. I want to talk a bit about my book. Since we seem to be at an inflection point where we are coalescing regulation and new laws, it seemed like a good time to start pulling together what we hope is only a first edition. I actually received my copy just before Christmas. Here it is. And it's surprising to think that when we proposed it to the publisher, we could only identify 2 laws that apply to AI, but it seems we found something to speak about. and it covers UK law and harmonized EU law. And I'll just put up there the sort of chapter subject so you can see the range of the practice areas it touches on. Now, my own expertise is IP, but I think by being the general editor of a book, I've really learned the importance of a holistic view when it comes to dealing with AI. And that's really the sort of technological developments, movements in the market, cross currents between practice areas, and the emerging regulation, and of course, the impact of ethics. And I want to illustrate those cross currents when I talk about IP strategy. So turning to IP, the key themes are that EU law and much of UK IP law was never designed for AI. It's patchy and it's really happenstance how the laws tend to combine and how they are interpreted. But I'll step through the key IP rights one by one. Then, as I said, I'll turn to trade secrets and contractual protections, and really then talk about the payoff between, or the decision to be made between a monopoly right and trade secrets, and really disclosure risk is one of the key points there. And then I'm going to talk a bit broadly about in Europe what those disclosure risks are. Now, my first point is the context of most of IP law as it was written, and really the fundamentals of patent eligibility for European patents were developed in the 1960s, and I've illustrated a typical 1960s computer. We are looking at mainframe computers, punch cards, and some early and very basic graphics, and really no internet at all, so ARPANET hadn't even been launched. And AI was an area of research at the time, but it was focused on symbolic approaches in which human programmers attempted to replicate human logic and code. And so really, this fundamental law was set 50 years before the current advances and this sort of step change in machine learning over the last decade. And those have, of course, enabled by the technology, so greater computing power and memory, but also the availability of extremely large data sets, in part from the internet and e-commerce. Now, one outlier to that general trend is copyright in the UK. So the UK's Copyright Design and Patents Act of 1988 allowed for computer-generated works. And that covered literary, artistic, musical, and dramatic works, and also unregistered designs. But it was such an outlier within Europe that the approach was rejected by the EU as premature when it was drafting its first directive on the copyright in software in 1991, and it was still not implemented as a concept in the revised directive on software 18 years later in 2009. So except for that one example in UK copyright law, UK law and harmonized EU law on IP was never designed to address two of the current developments. One is the importance of data, and secondly, the emergence of machines able to produce human-like outputs, including literary works for the purposes of copyright and inventions for the purposes of patents. Now I'm going to step through three parts of the key AI assets, so the inputs, then the technology, and its outputs. So talk about the inputs first. I'm illustrating that with some wonderfully creative training data, pictures of blueberry muffins and chihuahuas, which is obviously incredibly important for a visual classifier. And I want to talk about data. And first, one has to consider the terminology, because data can mean mere information, pure data, mere data, depending on if you want to qualify it. But actually, I think the term data is often used to mean the source material on which you're training. And so it could, in fact, be in the form of a copyright work, a photograph, or an academic article. And so you may face, you may have protection for your data to the extent it's in that form. But information per se, even the information within that copyright work, is not protected by copyright in the UK or Europe. And the UK court has explained this in the terms that copyright exists only in the literary form in which information is dressed. And really that reflects the thrust of international practice. So both TRIPS and the WIPO Copyright Treaty provide that copyright protection extends to expressions and not to ideas, procedures, methods of operation, and mathematical concepts as such. Now, that doesn't call out data, but it's clear that what is protected is the expression to the exclusion of other things, such as information. Moreover, even where you are extracting information from a copyright work, and that does typically involve copying, the UK and the EU provide some exceptions to infringement for the purposes of data mining. So since 2014, the UK has had an exception to copyright infringement, but that was limited to non-commercial purposes. So if an academic was mining copyright works, they were allowed to do so. Now, the EU in 2019 adopted a wider exception in the Copyright Directive, and that applies to commercial purposes, but it is subject to an express and suitably communicated reservation of rights by the owner. Now, how that's going to be done remains to be seen, because they're really thinking about information you might be scraping from the internet, and where should that reservation of rights happen. It could be in a robot text file or on the page itself, but what happens when the image appears elsewhere? How do you keep expressing that reservation of rights? But moreover, there is an absolute exception for non-commercial purposes, but it's wider than the UK's exception because it also applies to cultural heritage institutes and research organisations. And it appears that the definition of the latter might cover, for example, collaborations between commercial companies, maybe life sciences companies, generating pooled data resources. Now, since the UK has so far declined to implement the wider exceptions that the EU is carrying on with, and post-Brexit there is no requirement to implement such a law, we may see within Europe, and indeed more widely, differences in jurisdiction as to their allowance of data mining, which may create favourable areas to do data mining because of the local exceptions, and conversely, companies that have valuable sources of potential data to limit access to jurisdictions where these exceptions do not apply. Now, information per se is also not protected by the EU sui generis database right, despite its name and the promise it seems to hold. And the protection of databases expressly excludes the works, data, or materials themselves within the database. Now, what you hold is a valuable training set, if actually someone needs to copy all of it or much of it to make use of it, that might be a moot distinction, and effectively the database right is what you need. But actually, for many years, the database rights have been considered of very little practical use. I think most significant for a US company is, of course, there are no similar rights outside the EU on which to establish a reciprocal recognition of them. Also, very early on in the history of the database right, in 2004, a series of cases cut it right down in its scope. And that is because the definition requires that there's been investment in the obtaining, verifying, or presenting of the contents of the database. And they held that where a company incurs the cost of generating that data in the first place, that is not the right kind of investment to reward them with a database right. And this has come to be known as the spin-off doctrine. If the data has spun off another business activity, you can't get database rights for it. And that is obviously a huge blow to maybe, again, a life sciences company which is generating vast amounts of clinical trial data, but it can't protect that as a database right because it would have incurred those costs anyway. However, I do think this shorthand, because that's all it is, it's a sort of a summary of the case law. It's not actually what was said exactly in the judgments, even though it's widely believed. I think that is worthy of re-examination because when it comes to ingesting data into AI for training purposes, there is in fact a lot of investment potentially in processing that data, in checking for bias, in creating synthetic additions to it and the like, which might be the right kind of investment to allow you to attract database right after all. Next, I'm going to talk about the protection in Europe for AI techniques and technology. And patents are clearly the most visible sign of interest in protecting AI. Because it requires applications to pursue a registered right. So people can count them up and figure out that there's been, for example, about 800% growth in the last 10 years in applications relating to AI according to the UK IPO's analysis, and also WIPO and other patent offices around the world. But this growth, in fact, disguises, I think, considerable problems with patenting in this space. And there is a wealth of cases on protecting AI by patents. And what I've illustrated there is the first specific guidance from the EPO from 2018, which has subsequently been revised, but specific guidance on the protection of computer-implemented inventions, because they recognize the increased demand and that really people need to educate themselves more on the viability of patents. Now, this is a huge field, and I can't hope to summarize it on a talk like this, but I would make a few brief high-level points that it is in fact relatively difficult to get patents in this space, despite the number of applications. First, many AI techniques are old. The fundamentals are very old. Some of them, they go back to the 1940s and beyond, and even things like machine learning have been around, sort of fundamental concepts have been around even before our computing power enabled it to reach its full potential. The second is that they face exclusions in the patent systems of all countries, and particularly mathematical methods and computer programs as such for the purposes of European patents. And even if a patent is secured, there is doubt over whether it will continue to be held to be valid. And that is because there's always the risk of a shift in case law, just as the US experienced with Alice. And so there's always a risk of unknowns where the law changes, but there's also a current considerable problem already identified, and that is widespread uncertainty over the requirement for sufficiency. So that is the amount of disclosure required to enable the skilled person, when reading the patent, to be able to work the invention. And that is a subject of ongoing study by various IP groups and by patent offices. But the case law may crystallize at some point, and we may find that some of the earlier granted patents in AI are subsequently found to be invalid. Now, the other protection for the technology is software. And that is suitable for a platform someone has written to allow third parties to develop AI, where someone has written a suite of code and you have your software, and that protects you against someone copying the actual code you've written or translating it to port it between platforms, between OS systems. But it's very important to realize that this only applies to software when written by a human, and that is by definition, and that's harmonized across EU law. And the harmonized EU law also expressly excludes protection for ideas and principles which underline any element of a computer program. So copyright cannot be used to actually protect the actual technology. That is what a patent is for. So now I'm going to move to outputs, the AI outputs. I'm illustrating that with two examples. One on the left, a series of what appear to be artworks, and in fact what were assessed by members of the public to be art, but were in fact generated by an AI. And on the right, some poetry generated by AI. But obviously the outputs of AI can be immensely valuable, such as a new drug target or a new effective molecule, something which could be monetized in the millions or billions. So machine learning can output patterns in data, classifications of inputs, and it can output, objectively at least, things which resemble art, music, and inventions. But there are many challenges to IP protection for the outputs of AI in Europe. In common with the US, both the EPO and the UK IPO received applications in relation to the inventions claimed to be made by Debus. So Debus, as many of you will know, was an AI invented by Stephen Thaler, and he said in his submissions to these patent offices that the AI alone, without any meaningful human intervention, had come up with two inventions, one essentially for a container and the other for a light that flashed in a certain way. And he is pursuing these applications in multiple jurisdictions. And we've had first instance judgments from the UK IPO, from the EPO, and from the US PTO. And in the UK, it has also gone on appeal to the UK High Court, and that has also given its decision. And it is a typical effect of the fact that IP law was written at a time when such inventions were not considered. And really, it's no surprise that it's not patentable where your invention has been created by an AI. The case law has, the judgment has decided that a human inventor is required. And that is for a mix of administrative reasons, such as forms which require the name of an individual, but also two fundamentals. One, it was found in the UK that our Patents Act was written in such a way that the inventor is construed to be human. And secondly, that an AI, because it lacks any legal entity, cannot own the rights to the application and cannot pass them to the applicant. So on multiple threads there, it was impossible to patent an invention by an AI. Now, this is the impact of this is not yet entirely clear, because what we have is a real debate in the community about whether this is actually realistic, whether AIs will in fact begin to generate inventions without meaningful human interaction. And it's important to remember, and this is often misreported, that none of the patent offices nor the High Court made any finding that the Daibus AI in fact made the invention. All of the judgments were made on the assumption that it was the inventor. And in my travels talking to clients and at conferences, I see a range of opinions as to whether this is possible or likely in the near future. And I think it's of particular significance for life sciences companies, where under conventional doctrine, at least in Europe, you have your invention when you have a plausibility that your new drug will be effective for a new indication or a known drug for a new indication. And thereafter, the expensive and time-consuming clinical trials don't actually contribute to the inventive step. So if a AI were to identify such a suitable candidate and to make it plausible, arguably it has created the invention at that point, and you may then not be able to get IP protection downstream. Now, the practical effect of that is questionable, because I think there's a grey area, and there is as yet no case law to distinguish the boundary line between AI being used as a mere tool, as a human, as being, and where it is an autonomous inventor. And there's an important difference in practice between the US and UK and EPO practice in this regard, which is there is in fact in the US there are genuine penalties for not naming the correct inventor. And I believe if it has been wrongly named and there is fraud in the US, the patent would be unenforceable. But in Europe, there is no effective deterrent to naming a human as an inventor, where in fact an AI had made the invention. Now, returning to the UK and computer-generated copyright works and designs, although we've had this law on our statute books for 30 years, there is in fact only one case on the point, so there is little evidence of it having been used up till now. That was actually a case my firm did and won. But actually since then, the law may have changed because of EU harmonization to actually invalidate the effect of our claim to protect computer-generated works. And that is because when the software directive in Europe was put into force, it harmonized the test for originality for copyright works. And it now requires, whereas in the UK it only required that it hadn't been copied from someone else and it required sufficient skill, it now requires the author's own intellectual creation. And there are many commentators who believe that that cannot be satisfied by an AI. And so although the UK law has rules for who would own an AI, a copyright generated by an AI, because of a new test of originality, that copyright will never arise by definition for someone else to own it. So that leaves trade secrets. And I don't actually have the slide of trade secrets. I'll go back to that. But that leaves trade secrets as the de facto most likely protection in Europe for AI, because it is clearly broad enough to protect information, including algorithms and data. And indeed, the largest AI dispute to date that I'm aware of, the Waymo Uber case in the States, ended up focusing on trade secrets. And in the UK and in the EU, by definition, trade secret has to have been subject to reasonable steps under the circumstances by the person lawfully in control of information to keep it secret. So there will be a requirement if you come to court to defend your trade secret to actually prove that you've taken reasonable steps to keep it secret. So that in practice means not only should you take steps, but you should take such steps as you can easily log and record and turn up to court and prove. And so that includes practical measures to keep information secret, such as restricting physical access to the data, also electronic means to restrict access to the data, so who has permission to see it, password protections, access logs, and then again, measures to restrict or to monitor use of that data, so to monitor for transfers out of the company by email or into cloud storage or memory sticks. And all such practical measures should be backed up with staff training and staff handbooks and the like. And of course, legal measures as well. So non-disclosure agreements where you're dealing with employees or contractors or third parties, terms of employment to keep trade secrets protected, and that those should extend beyond the term of their employment to keep them protected. And of course, enforcing your policies internally. Now, where you have fallen out of that definition because you can't prove you've taken such measures, in the UK, hope may still lie in the common law right of confidential information, which doesn't have as rigorous a definition. And so it may be still possible to bring an action in the UK in particular. Another point of note in the UK is while some EU countries are getting their heads around trade secrets, where some always have had it, the UK court has a long track record of being able to hear disputes over secrets in camera where the public does not learn the secret. And I think some European jurisdictions are having to catch up. It's a requirement under trade secrets that happens, but the procedural mechanisms may be not as developed as they are in the UK. So then I should also talk about contractual protection, because that's the other de facto way to protect your AI assets when traditional IP rights fail you. And the first point is obviously that you should have obligations in contracts to protect, say, trade secrets by requiring people to pursue the same practical measures that you pursue. And in the UK, it is legal to treat assets which aren't in fact eligible for IP as if they did attract IP as between the parties. And IP rules should also be clarified in contract as between parties. So the positions on ownership of actual IP and indeed the control of things which aren't IP. And so really you're wanting to avoid reliance on the default rules in statute. So returning to the UK's computer generated rights legislation, there's a default rule of ownership, which is that a computer generated copyright work belongs to the person by whom the arrangements necessary for the creation of the work are undertaken. Now, that's obviously open to interpretation. There's also a total dearth of case law on it. So you want to clarify that in your contract rather than rely on applying the case law. And if you think of an example as complicated as a self-driving car, you may have rivals for the ownership and or control of information and technology, including the OEM, the equipment manufacturer, the dealer, the after-sales supplier, the first owner, subsequent owners, drivers and passengers. So a web of contracts would be ideal to clarify who has control of the valuable data arising from those circumstances. So I'm going to end with talking about the ideal, which is a holistic strategy for IP. And I think this applies particularly to the choice between patents as a monopoly right, where you are protected regardless of disclosure. Indeed, it's part of the social contract that to get your patent, you actually disclose your invention publicly. So the choice between a patent and trade secrets, which obviously rely on being able to keep your information secret. And so that is often a case of assessing the risk of disclosure. Now that is, I think, common in any patent attorney's practice, that when someone comes to them with any potential patent, they ask them if they'd rather keep it secret. But I think the question is particularly acute when it comes to AI technology, and it is also subject to many, many moving pieces. And so I'm just going to outline some of the considerations. So I think you need a holistic view of the technology, the market, and developing law. So first of all, some machine learning based applications, some of the inputs, some of the outputs are more or less vulnerable to reverse engineering. And the example I've given here is a complex product on the left, a self-driving car, where to reverse engineer it and to copy it may be far more challenging than a simple molecule, which are illustrated on the right. So in the life sciences sector, if you are launching a small molecule into the marketplace, you need some sort of monopoly right in order to stop people immediately cutting into your market. And that would be a patent, ideally, or the quasi monopoly right of data exclusivity, which can give life sciences companies up to 10 years of protection, because no one can get marketing authorization on the back of their data within that time. However, I think what is emerging over the last few years is in fact that reverse engineering can be applied to more complex embodiments of AI to extract training data and the like. So the example I hear about is the camera on a self-driving car that enables the car to identify the pedestrian and the cyclist and the like by having a video stream and producing labels. Now, the risk is that actually, if you run that for long enough, you end up with a whole set of training data, which you can then train a new AI on to do the same task. And I'm told that that is a real world problem for some of these manufacturers, and that they rely on contractual exclusions that their customers cannot reverse engineer a data set in this way. But again, concentrating on Europe, I would issue a warning that the software directive in Europe, which is also still in force in the UK, voids contractual terms that prevents reverse engineering through the normal use of the software. So I think care would need to be used in the drafting of such an exclusion for products sold for use in Europe. Now, other disclosure risks which are unusual to AI. First of all, AI and machine learning specialists are relatively likely to move between companies. They are, if I can generalize, smart, techie, maybe millennial. They love a startup, and demand outstrips supply, so they can move if they wish. And leavers, even under trade secrets, are going to be free to use experience and skills gained at their employer. So you need to be quite clear in your contract to identify trade secrets as such, and not merely experience and skills, to try to make sure they can't use it elsewhere. And also, Many of our clients need to attract AI specialists with an environment where they're allowed to publish their findings, either as journals or if suitable as a patent. But because they do want to publicize what they do, there is an inherent disclosure risk there. Also, at least in Europe, AI and machine learning projects are typically involve collaborations between maybe 4 or 5 parties. So you would have a data supplier, the customer, the platform supplier, the data scientist, and the like. And so you've got an increased risk of disclosure inherently because of the number of players, but also where you're having to tap up the expertise of an academic, they absolutely want to publish their result. And so you may need to seek a patent before they do so because of that disclosure. And obviously, you want to have contracts with your collaborators to cut down on these disclosures, but they are real. Now, the next real risk here is regulation. And I think it's fair to say that the EU is keener on regulating AI than maybe the US, or is at least further along that path. And there are many signs that this will end up introducing requirements for disclosure of algorithms or data sets. That would be to prove safety or robustness or fairness. And in Europe, there's already within the GDPR, Article 22, and that relates to the need to explain to consumers where a significant decision made about them has been done so automatically, and potentially to explain how that algorithm has made its decision. And the UK's Information Commissioner's Office, that is responsible for privacy law in the UK, has issued not 1, not 2, but 3 volumes of advice on how your AI needs to be explained to consumers. And finally, there is a lot of talk in Europe about competition authorities who may wish to enforce the sharing of data to promote competition. And there are, I'm afraid to say, frequent references to eroding the incumbent position of what is called big tech, and occasionally mentions of specific US big tech companies in that regard. So on that cheery note, I will stop and leave it open for some questions.
Thanks very much, Matt. That was fascinating. This opening up the Q&A chat, we've had 2 through while you were speaking, so we can start with those, and hopefully some more will come through. So the first question, are there moves to change IP laws in the UK and the EU?
Absolutely. So I would say there are consultations at least going on, but that's international. So WIPO's had its 3rd conversation on AI already, but the EPO's had a number of conferences, particularly trying to get information from the users of their service, essentially, on what they need. And the UK IPO completed a consultation, the round of gathering evidence in November. Now, the European Parliament has published some references to considering some sort of new rights specific to AI, but has yet to sketch out what that might be. They even flirted a couple of years ago with the possibility of giving AI some sort of legal rights, which of course might solve the problem of patents, because then it could own the right to the patent application. There's really no word yet from the UK legislature about what it might do about AI, but that's really because I think the UK IPO's consultation is still ongoing.
Thank you. And the second question, are regulators conscious of the disclosure risks they present to company trade secrets?
Certainly IP practitioners are well aware of that, and it's come up certainly on the WIPO consultation, that there's a threat fundamentally to trade secrets if regulators want to know more about your algorithm or your data. I think the regulators themselves are currently focused on safety and the fundamentals and haven't really addressed that point particularly. And I would say as a general point, at least in Europe, some regulators have been quite transparent about the fact that they just don't have the expertise in-house to develop their regulation. And so I think getting to those finer points is sort of beyond their scope at the moment. And then the only thing I have seen is some of the DGs of Europe that specialize in various sectors have expressly mentioned this to the European Parliament as a risk. So, you know, watch the space. We'll see what happens.
Will do. Interesting. We'll maybe give it a minute to see if there's any other questions that come through. But I guess while we're waiting for that, thank you very much for the presentation on what is a very exciting and quickly developing, to say the least, area of law that will surely keep you on your toes for many editions of your book to come. And I don't think any further questions are coming through. So I think we can bring the presentation to a close at that point. Thank you very much for joining, everybody. Matt, any closing remarks?
Well, I would have loved to have heard more from the members of their experiences, because, you know, Silicon Valley is obviously one of the key locales for AI development. So questions or comments would be welcome. I can see something splashed up. What is that?
Oh, we've had a compliment. Great presentation.
Okay. Thank you, Richard. It was my pleasure.